One of the most important moments for the future of our democracy happened this month, but you might have missed it among the melee of things that were going on.
This is already the third longest government shutdown in U.S. history, and one congressman I spoke with tells me there's no end in sight.
Fiery testimony on Capitol Hill. Attorney General Pam Bondi taking tough questions today as Democrats seize the opportunity to grill the nation's top law enforcement officer on a number of controversial moves by the administration.
Organizers say more than 7 million people gathered at nearly 3,000 events across the country over the weekend for No Kings rallies.
No, it wasn't any one of those things. What I'm referring to was an argument before the Supreme Court challenging Section 2 of the Voting Rights Act. It springs from a case called Louisiana versus Calais, in which a congressional map has been challenged on the basis that it diluted voting strength of the black community, and then on the basis that it gave too much weight to the voting strength of the black community. Let me explain. So in 2020, Louisiana redraws its congressional map. Louisiana, by the way, is about a third black, and they redrew the maps to dilute the voting strength of the black community. Louisiana at the time only had one black representative in Congress. Now, organizations challenged that 2020 map because it diluted the voting strength of the black community, and they were successful. And in 2024, a new map was drawn that elected yet another black representative to Congress. That decision, the new map of 2024, was also challenged. And it's that case that's before the Supreme Court. Now, here's the thing. If conservatives can do away with Section 2 of the Voting Rights Act, it will dramatically impact not just black representation in Congress, but it will also dramatically impact Republicans' chances of holding the majority in Congress even when the country votes against the Republican agenda. And what do I mean by that? It will allow Republicans to go through yet another round of gerrymandering. It could eliminate over a dozen more Democratic districts and minority districts in the country and have the effect of tilting the playing field even more. That is, an even more unpopular Republican majority could withhold its majority because it so gerrymanders these districts to eliminate minority representation. And the effect could be a map that goes from looking like this to one that looks like this. Now, during the oral argument, this is what Kavanaugh had to say.
This court's cases in a variety of contexts have said that race-based remedies are permissible for a period of time, sometimes for a long period of time.
But it's not the court's role to decide how long a statute, how long a law like Section 2 of the Voting Rights Act should remain in effect. No, that should be up to Congress. And Congress didn't put an expiration date on this. And indeed, the problem of the dilution of minority voting strength continues. And the problem of discrimination continues. And therefore, the viability and the importance of Section 2 continues. But here's the thing. The problem isn't just Kavanaugh. The problem is also, as in so many things affecting the Supreme Court these days, John Roberts, the Chief Justice. John Roberts, ever since he was a 26-year-old in the Reagan administration, has wanted to do away with features of the voting rights legislation enacted in the mid-1960s as a part of those civil rights reforms. He has made this a personal crusade of his over the years. And here he is suggesting that, well, maybe there's wiggle room for him to do exactly that.
You've said several times that it's playing an outsized role. What's the proper size? In other words, is that wiggle room we're talking about?
But there shouldn't be wiggle room, not if you're bound by precedent, as Roberts, of course, promised he would be when he testified at his confirmation hearing.
Judges and justices are servants of the law, not the other way around. Judges have to have the humility to recognize that they operate within a system of precedent shaped by other judges equally striving to live up to the judicial oath.
But we have seen the willingness of Roberts and his court to depart from precedent over and over and over again, whether it was the Dobbs decision overturning reproductive freedom or the immunity decision empowering Donald Trump to continue committing lawless acts and be free from any kind of repercussion, or now it appears Roberts' inclination to overturn Section 2 of the Voting Rights Act. But to do away with this key part of the Voting Rights Act when discrimination is still all too much a feature of our political landscape, Ruth Bader Ginsburg once said, in relation to a different effort to dismantle the voting rights legislation of the 1960s, this: throwing out preclearance when it has worked and is continuing to work to stop discriminatory changes is like throwing away your umbrella in a rainstorm because you're not getting wet. Sadly, the Roberts Court has done nothing but throw away the umbrella while we are getting wet. While indeed there is a deluge going on, while indeed our democracy appears to be drowning. But I'll have a lot more to say about Justice Roberts in part 2 of my examination of the court. Subscribe here to see it first.